Hi, my name's Corryn Wild, and I'm an independent and sole accredited chartered financial planner at 3 counties. Power of attorney is a document which allows somebody to make decisions on behalf of somebody else. Now, many of us might assume that if at any point in the future, perhaps due to illness or injury, we're unable to make our own decisions, that a trusted friend or family member would be able to step in and make those decisions for us. But that's not actually the case. Not even a spouse can make decisions on behalf of their spouse if they lose capacity. What needs to be in place is a legal arrangement which gives them permission to do so. And that's where a power of attorney arrangement can step in. So you can set up a lasting power of attorney for either health and welfare. So for example, making decisions regarding care that you might need in the future and the way that care is administered, or for property and financial affairs. So for example, paying your utility bills or dealing with an investment portfolio. These are two separate power of attorney arrangements. If you wanted to put both in place, you would need to complete two separate powers of attorney. And when they're in place, it will allow the attorneys that you've chosen to make decisions on your behalf. The point at which these documents come into effect does vary depending on which arrangement you have. So if it's power of attorney for property and financial affairs, you can ask your attorney or attorneys, if you've appointed more than one, to make decisions on your behalf for you if you have capacity. So if you perhaps can't really be bothered with dealing with an investment portfolio, perhaps you have dealt with it all your life, it's too much hassle, too much paperwork, and you have a son or daughter who you trust to make investment decisions on your behalf, you could allow them as your power of attorney to make decisions for you and perhaps liaise with financial advisors or deal with the bank and savings and such like without you needing to be involved. If you lose capacity, the people you've appointed as attorney can step in as well. However, the property and financial affairs power of attorney works slightly differently to the health and welfare power of attorney. So with a health and welfare power of attorney, this one cannot be used until you lack capacity. So until you are unable to make the decisions for yourself. At that point, the health and welfare power of attorney can be used, and the people who you have decided to act as your attorney can start making decisions on your behalf. As you can see, you're giving quite a lot of power to the people who you appoint as attorneys. So it's important to make sure that you appoint people who you trust, ideally people who know you and your preferences and what you would want to happen, who can then make decisions which are likely to be in your best interests and hopefully in line with decisions that you might have once made yourself. If you are struggling to find someone to appoint as an attorney, it is possible to appoint a professional who will act on your behalf as well. So this could be, for example, a solicitor. Once the power of attorney documents are in place and registered, you're good to go. These arrangements will last until they're needed. However, if you don't have power of attorney in place and you lose capacity before putting these arrangements in place, you do need to go down a different route in terms of arranging for someone to be able to make decisions for you, which can be far more time-consuming and expensive. So certainly worthwhile considering, if you don't have power of attorney arrangements in place, that at any age, any of us could potentially lose the capacity to make our own financial decisions. Therefore, it's something that all of us should have on our radar as something important to get addressed and dealt with.